Today I want to talk about a problem Europe is finally starting to recognize more seriously: statelessness, not theoretical statelessness, not only the classic cases we usually hear about in international law textbooks, but the growing number of people inside Europe who are legally identified, administratively processed, sometimes even fully documented, and still remain unresolved. And nowhere is this contradiction more visible than between Germany and Greece. The latest developments from the European Union Agency for Asylum, the EUAA, reveal something astonishing. As of late 2025, only 8 EU plus countries had a formal statelessness determination procedure. Think about that carefully. Europe has one of the most advanced legal systems in the world. It has human rights conventions, child protection systems, migration frameworks, nationality laws, the European Convention on Human Rights, EU citizenship law, and yet, in most of Europe, there is still no proper legal mechanism to determine statelessness in a clear and structured way. This is not a small technical issue anymore, because from June 2026 onward, the new EU Pact on Migration and Asylum will begin reshaping how Europe handles migration, asylum screening, border procedures, and returns. And this changes everything for stateless people. The new system will become much better at identifying people, better databases, better registration systems, more screening, more coordination between states, more information exchange. But there is a dangerous question nobody wants to answer openly. What happens after identification? What happens when a person is recognized as potentially stateless? But no state is willing to take responsibility. This is where the Germany-Greece relationship becomes extremely important. For years, Greece functioned as one of the main entry points into Europe, while Germany became one of the main destination countries. And because of this, thousands of legal situations developed across both systems simultaneously. People registered in one country, families formed in another, children born in one jurisdiction but living in another, different administrative records, different assumptions about nationality, different interpretations of identity, different procedural requirements. And suddenly we are no longer dealing with a simple migration case. We are dealing with overlapping legal systems that do not fully communicate with each other. One country may recognize a family relationship. Another may require different documents. One authority may accept a correction. Another may require a completely different procedure. The result is what I increasingly call effective statelessness. Not always absolute statelessness in the classical legal sense, but situations where people cannot realistically access nationality, documentation, or stable legal protection within a functioning time frame. And the new EU migration system risks making this contradiction even more visible, because the pact focuses heavily on efficiency, efficiency in screening, efficiency in registration, efficiency in return procedures, efficiency in responsibility allocation. But statelessness cases are rarely efficient. They are usually exceptional. They involve migration law, family law, nationality law, human rights law, civil registration systems, diplomatic practice, and administrative coordination all at the same time. And ordinary bureaucratic systems are not designed for that level of complexity. This becomes especially dangerous when we look at the new discussions around return hubs. Several European states, including Germany and Greece, are discussing systems where rejected migrants could be transferred to facilities outside Europe pending removal. But here is the legal problem. What happens when there is no country willing to receive the person? What happens when nationality itself is unclear? What happens when identity disputes are linked to old asylum records, conflicting civil documents, or years of procedural contradictions between different states? These are not hypothetical scenarios anymore. These are already emerging realities inside Europe. And now let's talk about Germany specifically. Germany's nationality reform from 2024 included major positive developments: the 5-year naturalization rule, acceptance of dual citizenship, reduced risks of automatic loss of nationality. These are important modernizations, but there is another side to the reform that receives much less attention. Germany also strengthened rules against false information and identity inconsistencies, and for ordinary fraud cases, that is understandable. But for stateless people or people trapped in fragmented cross-border documentation systems, this creates enormous risks. Because many people affected by statelessness do not have clean administrative histories. Their files may involve different spellings, different registrations, missing archives, old asylum identities, or conflicting records across several countries. Especially in Germany, Greece cases, these contradictions can accumulate over many years. And this creates a dangerous possibility. Structural administrative failure may be interpreted as intentional deception. That distinction is absolutely critical. Now, interestingly, the European courts are beginning to move faster than the political system itself. Recent case law from the Court of Justice of the European Union increasingly says that nationality decisions are not completely untouchable when EU citizenship rights are affected. The courts are strengthening procedural safeguards, proportionality, individual assessment, due process protections. At the same time, the European Court of Human Rights remains more cautious. Strasbourg still tends to treat nationality as primarily within state sovereignty. But even there, pressure is growing, especially in cases involving deprivation of nationality that may leave people stateless. So we are entering a new legal era, an era where statelessness is no longer invisible. But here is the paradox. Recognition alone is not enough. Europe is becoming better at identifying statelessness, without necessarily becoming better at resolving it. And that may become the next great structural problem of European migration law. Because a person can now become registered, screened, classified, analysed, documented, and still remain trapped in legal limbo. This is why the real European problem today is not only legal, it is procedural. Europe already has conventions, principles, human rights frameworks, child protection norms, but it still lacks a coherent mechanism capable of resolving exceptional cross-border cases that fall between multiple legal systems. Germany and Greece expose this weakness very clearly, not because one country alone created the problem, but because together they reveal how difficult it still is for Europe to manage complex human realities that do not fit neatly inside ordinary administrative categories. And this is why statelessness is no longer a marginal issue. It is becoming a structural test for the future credibility of European law itself. Because the real question Europe now faces is simple. Will the system eventually learn how to solve these cases? Or will it merely become more sophisticated at administrating unresolved lives? Thank you for watching.